Hello, 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 hello. Hello, hello.
respected teachers, dignitaries on the dais, the college union members, and my dear students. A warm good morning to one and all present here. Government Law College Ernakulam, established in 1874, is entering into its 150th year of glory. The College Union 2023 has been thinking of numerous ways to celebrate this. And then came to the conclusion that in this era, even after years of freedom, we are still fighting for our rights. So, the College Union decided to hold a national conference on the Constitution in a changing India. Let us say that this is the first student-organized national conference ever held in Government Law College Ernakulam, and just a beginning to a spectra of events yet to start. The union has put weeks of effort to make this day happen. So, welcome to the first day of the most anticipated National Conference 2024. On behalf of the College Union and the students of Government Law College Ernakulam, I would like to express my immense pleasure of having Advocate Indira Jaising today with us. Indira Jaising is a prominent Indian lawyer and human rights activist known for her extensive work in advancing women's rights and championing civil liberties. She has had a distinguished career spanning several decades. Jaising co-founded the Lawyers Collective, an organization that provides legal aid and advocacy on issues like domestic violence, gender equality, and public health. In 1986, she became the first woman to be designated a senior advocate by the Bombay High Court. She was the first woman to be appointed as the Additional Solicitor General of India, serving from 2009 to 2014. Throughout her career, she has been involved in numerous landmark cases, including those related to environmental issues, sexual harassment, and discrimination, earning a reputation as a fearless advocate for justice and social change. We are more than happy for your presence here, ma'am. So, to welcome you all with an official welcome note, I would like to welcome our faculty member, Premsi ma'am.
Ladies and gentlemen, honored guests, esteemed colleagues, my dear students and friends, it is my pleasure to welcome you all to this commemorative law lecture on constitutional imperatives of an independent judiciary as part of our national conference on a much important topic, that is the Constitution in a changing India. Today, we know that we stand at the crossroads of tradition and transformation, reflecting on the enduring principles of our Constitution while contemplating the dynamic changes that shape our societies. Our Constitution, the cornerstone of our democracy, has been a guiding beacon for justice, liberty, and equality. It embodies the aspirations of our people and provides a framework within which we navigate the complexities of modern governance. However, as our world evolves politically, socially, and technologically, we must ask ourselves, how can our constitutional frameworks adapt to meet new challenges and opportunities? This conference brings together scholars, practitioners, and thoughtful leaders from diverse backgrounds to engage in meaningful dialogue. We will explore critical issues such as the protection of fundamental rights in the digital age, the balance of power between different branches of government, and the role of the Constitution in fostering inclusive growth and social justice. India's rich constitutional history offers a unique perspective on these discussions. Our Constitution, a living document, has withstood the test of time, providing stability while allowing for progressive change. It is a testament to the vision of our founding fathers and the resilience of our democratic institutions. As we embark on this journey of exploration and discovery over the next few days, I encourage each one of you to share your insights, challenge assumptions, and collaborate on ideas that can help shape the future of constitutional governance. Let us seize this opportunity to learn from one another and contribute to the ongoing evolution of our constitutional ideals. I would like to extend my heartfelt gratitude to all the organizers, speakers, and participants of this conference. Your dedication and commitment to this important cause inspire us all. With this, let me come to my assigned duty today. We have our beloved principal, Dr. Bindu Nambiar, presiding over this inaugural session. I consider this an opportunity to express our sincere gratitude for all support and encouragement she offers us towards fulfilling all the academic responsibilities. Dear Bindu Nambiyar ma'am, with much pleasure, I welcome you warmly to this meeting. Now, with great pleasure, I acknowledge that it is my privilege to welcome an incredibly remarkable individual to our conference today, Advocate Indira Jaising. We know Advocate Indira Jaising is a distinguished lawyer in India, renowned for her pioneering work in human rights and gender equality. She has been a formidable force in the legal field, championing the causes of marginalized communities and advocating for social justice. As the first woman to be appointed as Additional Solicitor General of India, she has broken barriers and set precedents for women in the legal profession. Her contributions extend beyond the courtroom. She co-founded the Lawyers Collective, an organization dedicated to promoting human rights, especially those of women and LGBTQ+ communities. Her relentless efforts in landmark cases such as those related to domestic violence, sexual harassment, and freedom of speech have significantly shaped Indian jurisprudence. Indira Jaising's contributions have been recognized with numerous accolades, including the prestigious Padma Shri Award. Her work embodies the spirit of our conference on the Constitution in a Changing India, as she continually challenges and redefines the boundaries of constitutional rights and protections in response to these political and societal changes. We are truly honored to have with her us today. Please join me in giving a warm welcome to Advocate Indira Jaising. Now I extend my heartiest welcome to Dr. Minnie Paul, Associate Professor and Staff Advisor to the Union of our college. Dear Minnie Paul ma'am, I wish to appreciate all your efforts and guidance, and I warmly welcome you to this session. Now I welcome Sanjana, our General Secretary, Vice Chairperson of the Union, who has been behind this program, I think months before. It is not only weeks dedication, but months dedication is there behind this program. Anyway, I congratulate all the persons behind Sanjana, and I extend my heartiest welcome to Sanjana also to this wonderful gathering. Now we have got other eminent persons who has accompanied our chief guest, Advocate Indira Jaising, Sanobar Keshwar, as well as Advocate Lekha Suresh. I welcome them also to this gathering. Now we have got our senior faculty member, Dr. Girishankar SS. We know that for every effort, and I think all the advisors, etc., for the effective working of this, or effective, what we call, the person behind this person is none other than Dr. Girishankar SS. We actually thankful towards, we actually wish to express all our gratitude to Dr. Girishankar on behalf of the students also, and I extend my heartiest welcome to Dr. Girishankar SS also. Now I wish to extend all my heartiest welcome to all the faculty members assembled here and senior students, as well as all my friends and students. I welcome all of you, welcome to today's session, and I extend all what we call all my wishes for the successful ongoing of this session, of this conference also. Thank you, Anandu.
Thank you, Premsi ma'am. Now I would like to welcome our principal, Dr. Bindu Nambiyar, for the presidential address.
Good morning, everyone. Respected Advocate Indira Jaising, Dr. Premsi, Dr. Minnie Paul, Sanjana, my dear colleagues, ladies and gentlemen, and my dear students. Today, we are going to celebrate the national conference which was organized by our students, the College Union. They have very well coordinated, and they have been working non-stop for these past 2 months. I congratulate each and every one of this team who have helped in organizing this conference. Now, we all know that this year we are celebrating 150th year of our college. It is something which is great because only very few colleges or institutions can claim this acclaim, that is 150th year celebration. And we are going through that phase. And our college union has taken this opportunity to conduct this conference, and also in a topic which is very relevant to our time, the Constitution. We all know that in a democratic country, the most valued document is the Constitution. And our Constitution is very good Constitution and a living and breathing Constitution. It is being developed and being changing. And the Constitution has envisaged for the separation of powers. And the most important is, for a democratic country, it is the independence of judiciary. And this independence, which marks the value of democracy. Each and every person has got their liberty, whatever rights they have. It is being safeguarded by our judiciary. And we all know that in order to safeguard the independence of the judiciary, our Constitution have envisaged many provisions. And all these provisions are there. Along with that, we should have a judiciary which is rendering justice. It is the fair and independent justice should be rendered to each and every person of this country. It is the duty of the judiciary to render that. And in this scenario, we also should think whether we are getting it. And we all know that there is delay in rendering justice. And we all know that delay in getting justice is delaying. So we should get a judiciary which will render justice immediately. Then only the purpose will be served. And each and every individual of this country has got a right for that. And we all know that there is independence of judiciary, and there is also duty on the judiciary also. Not only they have to render justice, but everyone should feel that justice is being rendered. It is the prime important factor. So we should hope that the judiciary will be able to render that. Thank you, Jaising.
Thank you, ma'am. Thank you for reminding us that the delayed justice is denied justice, which is of importance in the current scenario. Now, I would like to welcome our faculty union in charge, Minnie Paul ma'am, for the felicitation.
Respected Chief Guest of the Day, Advocate Indira Jaising, Senior Advocate, Supreme Court of India, Principal, Dr. Bindu M. Nambiar, Dr. Girishankar SS, Principal, St. Dominic's College, Kanjirapalli, College Union Chairman Isa Fahan in his absence, Sanjana, then Advocate Sanobar Keshwar and Advocate Lekha Suresh, faculty members, students and other participants of this function. A very good morning to one and all. Today marks a momentous occasion as we gathered here for the much awaited culmination of more than 3 months deliberation, relentless deliberations and efforts by the student community headed by the college union. It is with great pride and anticipation that we embark on a journey of knowledge at the National Seminar on the topic Constitution in a Changing India. We are indeed fortunate to have Advocate Indira Jaising, noted human rights lawyer and senior advocate, Supreme Court of India, to enlighten us on the topic constitutional imperatives of an independent judiciary. With her vast experience and deep understanding of legal principles, she would undoubtedly provide valuable insights into the crucial role that an independent judiciary plays in upholding the rule of law and protecting constitutional rights. The 3-day seminar on a very relevant topic will indeed go a long way in enlightening the participants on the changing facets of the Indian Constitution and its emerging challenges. I congratulate the organizers of this program, the College Union headed by Isa Farhan, Law Journal Club, and the BSSE for organizing this great event. My heartfelt congratulations and best wishes to all the organizers of this team. Thank you.
Thank you, ma'am. Thank you so much. Now, we are entering into the most awaited session by our chief guest, Advocate Indira Jaising. Ma'am, I would like to welcome you to begin the session.
Thank you, dear. Madam President, Madam Premsi, Madam Mini Paul, and most importantly, all the students present here today. And of course, former people like Lekha Suresh who've passed through the corridors of this college, and my colleague Sanova, who together with me founded the Lawyers Collective, which was mentioned. Most of all, I am very happy that this event has been organized by students, as the previous speakers have informed us and as the brochure also informs me. In particular, the Bhagath Singh Studies Circle, the College Union, are today my hosts, and I could not, in my entire career, have found better hosts. They are after my own heart. Now, the first thing that, when one talks about students, I am reminded of students across the world today. Some of them happen to be my juniors who have gone overseas to study at prestigious institutions like Columbia University and at other universities all over the world. And it's a matter of pride that I've seen the students protesting over the genocide which is occurring in Palestine. And on making a few inquiries, I found out that some students' protests were held here as well. Students, as we all know, are the future. Students were in the leadership of the anti-Vietnam movement, which brought the war to an end. And so I hope that the protest of the students of today will also bring this international war to an end. Now, let me come straight to the subject which has been assigned to me today, constitutional imperatives for an independent judiciary. I was initially preparing a lecture on independence of the judiciary, which would have been, telling you things you know already about how the collegium system came into being, how the collegium functions. But I thought this is something that you know already, and you have been taught that in your law schools, and therefore it's more important to focus actually on the Constitution itself. Well, Madam, your institution is 150 years old. It's a matter of pride, as you said. But for me, it is a matter of pride that I was born before the Constitution came into force. I'm ancient, and I may not be a founding mother of the Constitution, but I'm certainly a founding daughter of the Constitution, for sure. And I say this because of the word founding, F-O-U-N-D, founding. How do you found something? How do you constitute something? You found and you constitute anything, whether it's a constitution or an organization or an idea, with your feet. You work for it. And it is the work that we lawyers do in court that founds the values of the Constitution in our daily lives. And this is what I have sought to do throughout my career as a lawyer, and which is why I call myself one of the founding daughters of the Constitution. There are many, but I am one of them. Now, as has been said by the previous speakers, the Constitution of India does reflect the values of the freedom movement and also the quest for social justice. Remember, these are two different things. They are parallel movements, but two movements, and maybe more than two movements. The freedom movement was obviously a freedom from colonial rule. But the movement for social justice started long before the freedom movement, almost a century before that. It was a movement for reform, social reform. And it finds its culmination in the preamble to the Constitution of India and in Part 3 of the Constitution of India. Liberty, equality, dignity, and the guarantee of the fundamental rights in Part 2 are the culmination of more than a century of struggle before the Constitution came into force. So you're lucky. You are lucky. You have inherited something which it is your sacred duty to carry forward. So the Constitution was adopted at a time when the socio-political situation of the nation was marred by inequality. Hence, the Constitution became a document for restructuring the idea of India as distinct from being a colony or colonial entity. It became India. India, in the Constitution, described India, that is Bharat. Now, there is a very famous, well, I would say it's one of my favorite quotations from a judgment written by the current Chief Justice of India in the Indian Young Lawyers Association versus Union of India. Remember, this is a case which originated from the state of Kerala. It challenged the fact that women could not enter the Sabrimala temple. And I had the privilege of arguing on behalf of Bindu, who was also a lawyer and who went on to become the first woman ever, scheduled caste woman, to climb up the hill and pay her respects at the temple in Sabrimala. For that, of course, she paid a very heavy price. And I must tell you that so severe was the reaction of local communities against her that she actually left her home state, her college where she was teaching, and she's now trying to make her life as a practicing lawyer in Delhi. But this was, I would say it was really her contribution to the constitutional jurisprudence of this country, and I had the privilege of representing her in the Supreme Court of India. Now, here is a quotation from the judgment, which is really one of my favorite articulations of what the Constitution is all about, and this is what Justice Chandrachud said, and I quote, "Reading Dr. Ambedkar compels us to look at the other side of the independence movement. Because the struggle for independence from British rule, there was another struggle going on since centuries, which still continues. That struggle has been for social emancipation. It has been the struggle for the replacement of an unequal social order. It has been a fight for undoing historical injustice and for righting fundamental wrongs with fundamental rights. The Constitution of India is the end product of both these struggles. It is the foundational document which, in text and spirit, aims at a social transformation, namely the creation and the preservation of an equal social order. The Constitution represents the aspirations of those who were denied the basic ingredients of a dignified life, unquote. Now, this quotation, for me, is like my guiding star in all the work that I do. These are twin movements. The movement for freedom from any kind of authoritarian colonial rule and the movement for social change, struggle for social change, which culminates in the success of the adoption of the Constitution of India. And note that the Chief Justice says the struggle is continuing till today. Freedom is not a gift. Freedom is something that we fight for on a daily basis. Let's remember that. As you leave this institution and enter the legal profession, this is what you must remember. Now, what is the other remarkable? I think one of the previous speakers said that the Constitution is a remarkable document. Why is it remarkable? For what reason? Some of the reasons I've already articulated. But the other reason is that it establishes a secular India. Remember that the Constitution was formulated at a time of great communal unrest. Our constitutional makers were faced with two possibilities: the possibility of creating a Hindu nation and the possibility of creating a secular nation. Remember that Pakistan went a different way and created a nation based on Islam. What we must feel very proud of is that we created a constitution which in its preamble says that it is secular and which is not based on our religious identity. We are all citizens. We are all equal citizens, regardless of the religion to which we belong. In my opinion, the constitution makers were also influenced by international developments, because it was around the same time the United Nations Declaration of Human Rights was made. And if you see Part 3 of our constitution, a lot of it is taken from that declaration. Certainly our civil and political rights. But what is really important about our document is it sets out to dismantle established hierarchies. And it does so in several different ways. One of them is Article 15, there shall be no discrimination based on caste, sex, religion, residence, or any of them. And the other is Article 16, which promises representation, adequate representations to backward classes, scheduled caste, scheduled tribe, and other backward classes. And of course, Article 17, the dismantling of untouchability, the prohibition against untouchability. So what is all this? It is the dismantling of hierarchies. Now, I'm going to say a few words about this here from my personal life. When I started practicing as a lawyer, and when we set up the Lawyers Collective, I was under the impression that my role as a lawyer is to dismantle economic hierarchies. That is, the inequality that you see. And it was Justice Krishna Iyer who drew our attention to the Directive Principles of State Policy when he says that special attention has to be paid to the victims of what is mentioned in the Constitution as, quote unquote, undeserved want. Undeserved want. This country is full of undeserved want. There are 80 million people in this country receiving free rations because they are below the poverty line, because they can't afford to buy their rations, which are necessary to keep body and soul together. So you can imagine the extent of want in this country, and want which is undeserved only by reason of their birth. So this constitution was meant to dismantle those hierarchies, and I saw my own role as a lawyer in addressing those inequalities. And this is the reason why I chose to work for the pavement dwellers case when they were being removed from the pavements of Bombay by the then Chief Minister, the late Mr. A.R. Antule. And he said he wanted to beautify Bombay. And the middle classes of Bombay said that, you know, when they looked out from their high-rise buildings and looked down, they would see these people living on pavements, and that was a nuisance, a disgusting thing for them. The irony, of course, is that it was these very people who were employing these very people to come and work in their homes, do their domestic chores, the cleaning of the toilets and the cleaning of the home and the cooking of the meals in their own homes. And yet they said they are an eyesore, we want them removed. Now that was the motivation for me to do that case. I can never forget the fact that I made repeated visits to the Supreme Court of India to get stay orders. I would take a flight in the morning, come back in the evening, get my stay order and go home. And it was Justice Krishna once who told me, Ms. Jaising, the pavement dwellers have made you into an airport dweller. Every second day I see you flying down from Bombay to Delhi, getting a stay order and going back. But that was the role I cut out for myself. And after that, I addressed the issue of street hawkers. The Bombay Hawkers Union, which was founded by the late George Fernandez, he approached me and said, Ms. Jaising, what do we do about this issue where everybody is just being hounded out of the streets? Now, these very vendors, again, were almost the lifeline of the women of Bombay. On their way home from work, they would stop at Victoria Terminus Station, buy their provisions and go home at reasonable, affordable prices. So we took the case to the Supreme Court, and it was Mr. K.K. Venugopal, who was appearing on behalf of the Bombay Municipal Corporation. Now, there too, the argument was they are a nuisance. And it was the first time that I encountered in my life a human being referred to as a nuisance. And the municipal corporation used a law which enabled them to remove benches and boxes from the streets. Every corporation has this particular section that the power of the corporation to remove benches and boxes from pavements. And that is the power that they used. And I was in shock. I said, are you equating human beings to benches and boxes? Is that your case? You have not even given them notice. Unfortunately, the Supreme Court said this cannot be done, this power cannot be used, and there needs to be a scheme. Now, this is a slight diversion, but the diversion is because in those days, for many years, I was working on the issue of social and economic rights. But there came a time in my life where I had to deal with civil and political rights. And then you realize that these rights are indivisible, just indivisible. Why? Because I know I faced an FIR from today's ruling government, allegedly on the ground that I had violated certain laws of funding. Now that FIR is being dealt with, and I don't wish to talk about it because the matter is pending in court. I'm here before you because I'm protected by the courts. But what it made me realize is the interconnectedness between civil and political rights and social and economic rights. That's what came home to me. And since then, I have realized that the most important thing that you and I possess, which no one can take away from us, is our right to speak out. Nothing else. It's a very, very powerful tool. So the right to freedom of speech and expression, the right to organize, is the only thing that most of us have. We are not, at least I'm not, I don't know how many of you in this room are, but we are not the descendants of the Adanis and the Ambanis, okay? They have many, many ways in which they can influence governments. They can bribe. They can change policy. They can get onto committees. They can lobby. But what can you and I do? We can use our voice. We can use our voice inside and outside the court, And it is our powerful voice, it is the work we do with our feet that gives us the evolution of the Constitution as we see it today. Now, why am I saying all this? It's a lead up to the whole question of independence of the judiciary. So, interestingly, when we were sitting in the principal's room, I think it was Mr. Giri who pointed out to me that at one point this institution was known as the Maharaja Law College. Think about it. Just give it a thought. Not even 150 years ago. Not even 150 years ago. And what is it called today? It's called today the Government Law College. Now, I want to tell you that the judiciary emerges as an independent institution when monarchy ends. It is the end of the Raj of the Maharajas worldwide. We may call them Maharajas, but in the UK they were called kings and queens. And when that political rule ends, then you get the emergence of an independent judiciary. Why? Because until that time, dispensation of justice was the role of the king. And the king was considered the representative of the divine, of God. And so you had a devolution of power from God to the king, and the king would sit and do justice. Where was the question of an independent judiciary? So what you need to understand is the point in history where you get the evolution of a judiciary which is considered independent, which is considered independent of what? Independent of ruling powers, independent of parliament. Madam mentioned separation of powers. So separation of powers is not something that always existed. No. There was, on the other hand, a fusion of powers. You get a separation of powers only when you get incipient notions of democracy, when you get a change in the notion of sovereignty, when you begin to see that sovereignty does not reside in kings and queens, but it resides in we the people. And that is the time that we think of having an independent judiciary, a professional independent judiciary. Now, of course, all of you know, I'm taking it for granted that you know what the Constitution has to say. The Constitution, in fact, guarantees security of tenure for judges, irremovability except by impeachment for misconduct, guaranteed payments which are charged on the Consolidated Fund of India. These are all intended to insulate the judiciary from the executive, from all ruling powers. Now then, of course, it's up to you as a student community to decide whether our judiciary over the years has been able to keep itself independent from the executive, independent from the legislature, and independent from all other influences and ideologies other than the ideology of the Constitution of India. You know that judges take an oath of allegiance to what? To what? To the Constitution of India. And so the question when we discuss independence of the judiciary is, have they been faithful? Have they been faithful to the oath of office that they take? And I intend, in the time left to me, to address that question. In my opinion, in recent years, we have not seen this. We have seen the emergence of an ideology which is considered to be an ideology over and above the Constitution of India. Now, remember, we refer to the Constitution as the Grundnorm. We refer to the Constitution as the norm in the hierarchy of norms, with reference to which everything will be tested. What the executive does, what the legislature does, even what the judiciary does. What people do will be tested against the norms of the Constitution. But we are passing through times in which this Grundnorm is being replaced by another norm. And we are told that the anti-colonial we didn't get liberation from colonial rule in 1947. No, 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 we got it in 2014, and it's now continuing after 2014. The anti-colonial struggle started only now. Now, why? Where is this thought coming from? This thought is coming from the fact that we are a civilization of over 1,000 years old. And this is the civilization which is our Grundnorm. And what is this civilization? This civilization is captured in documents like the Vedas and the Manusmriti and Atharva Shastra. And much to my alarm, I have seen judges quoting from these documents to substantiate their judgments. Now, in my opinion, the Constitution of India represents a break, a sharp break, like with a knife, where you say the past is the past, this is my present, this is my future. And what is my present and my future is contained in the Constitution of India. I have to live by it, I have to die by it. But we see now a harking back to a 1,000-year civilization which is supposed to guide our actions. This goes contrary to the law declared, I would say, by the United States of America Supreme Court in 1803 in Marbury versus Madison, where it was said that a law repugnant to the Constitution is void, and that courts as well as other departments are bound by the instrument. What instrument? The instrument of the Constitution of India. The courts are also bound by it. So neither the courts nor the government can go beyond the Constitution to justify their own actions. That was the end of the doctrine of supremacy of Parliament as well. We in India do not subscribe to the doctrine of supremacy of Parliament. And here, a little bit of aside, I remember when the NJAC Act was struck down by the Supreme Court of India, the late Mr. Arun Jaitley made a statement. He said, "You have gone against the will of the people." Okay? But the fact of the matter is the judiciary has the power to declare laws unconstitutional, and they did it. So the argument that the judiciary went against the will of the people is not sustainable in law. You have Article 13, which expressly declares that all laws contrary to the Constitution are void. You have Article 226, you have Article 32, which is alone in the world giving you direct access to the Supreme Court of India. No other country has an Article 32 in the Constitution, a gift of Dr. Ambedkar. Incidentally, I think one of the reasons could be because what the student mentioned, that why are there so many delays? So we are the only country in the world where you can leapfrog the entire judicial process and go to the Supreme Court if you think that your fundamental rights have been violated and if you can establish that. So what I'm noticing now is that our fundamental rights have become unenforceable. They have become only an affirmation of political intent, and they are implemented at the discretion of our politicians or at the discretion of our judges, which is completely contrary to what. You see, what is happening in this country is duties are overtaking rights. Everything is now our kartavya. While I don't deny the importance of duties, can they ever override the fundamental rights? Can they ever be used to restrict fundamental rights? The answer is no, because the Constitution doesn't permit that. So it's like we are being told that, you know, our rulers are benevolent. You go back to the issue of kingship. And for me, nothing symbolizes this more than the installation of something like a songol in Parliament. Songol is a symbol of kingship. And we must ask ourselves the question, what place does it find in a republican country? None at all. And similarly, We have seen the consecration of a temple by a sitting prime minister. You must ask yourself the question, does the Constitution permit this? Is there no separation between the sacred and the secular? We have no problem with the right to freedom of religion. I don't have a problem with that. I have my own religious beliefs. And I practice them. But there is a time and a place to practice your religious beliefs in the privacy of your life, not in public life. So you must ask yourself the question, is the Constitution being implemented in letter and spirit? Is our democracy being protected as a democracy? Is republicanism in this country in safe hands? And these are, by the way, all legal questions. I think you will be called upon in the future to address these questions in a court of law. You must find the answers to these questions. So there is an 800-year-long history beginning with the pronouncement of the Magna Carta, which led to this separation, this what we call the independence of the judiciary. It took 800 years to achieve this separation of powers. And it is our duty now to make sure that this separation of powers is maintained. I read a headline in a newspaper very recently, and this statement was attributed to the Prime Minister. And I quote, "Ram is the idea of India. Congress cannot see it because they are using foreign lenses." Okay? Do you agree with this statement? Ram is the idea of India? No. For me, the idea of India is the Constitution of India, which has certain values and which has the separation of powers and the independence of the judiciary. Well, if Ram is the idea of India, you don't need a judiciary, do you? You don't. You can go back to the days of divine justice. Ram will do justice to us, all of us, won't he? Or does one refer to God as he? No. One has to refer to God as we. As students of law, you must ask yourself the question, is this the India of your dreams? Is this the India that you inherited in 1947, when, of course, all of you were not born? But you have this rich inheritance. It is yours to claim. And I know that I have claimed mine. And once again, a small aside, there was a time when I was getting very depressed when I saw students being oppressed. How many of you have seen the videos of the police entering JNU and beating up students? This was some years ago. Arrests were made, Kanhaiya Kumar was arrested, etc., etc. And there was a long fight for bail. And I can't remember the exact judgment, but there was a lady judge of the High Court who gave bail, and she referred to some music from Bollywood, which was valorizing Hindustan Hamara Hai, and so on. Of course, Hindustan Hamara Hai, but Hindustan Hamara Hai is not going to give you bail. And when Kanhaiya Kumar finally got bail, he came and addressed a meeting of the students, and he said over there words which are immortal. He said, "Azadi, Azadi, Azadi." And then I realized that my depression disappeared. And as I told you, at my age, I thought maybe we let down the student generation. Maybe we didn't hand over to them the values of the Constitution. But when I saw Kanhaiya Kumar say, "Azadi, Azadi," I knew that my generation has succeeded in handing down values to the current generation. So we do not wish to go back to some ancient golden age. At least I don't, and I hope you students don't want to either. Custom, culture, religion, these are all names for something other than the Constitution of India. What we are seeing in the country today is the use of custom and culture as a source of law, which we have to firmly avoid and stick. Now, there are judgments of the Supreme Court quite a few which I will not be able to list out completely, but there is one particular judgment I wish to draw attention to, which epitomizes this change. And that was the judgment dealing with the marriage equality case, where one of the judges explicitly says that in our country, the institution of marriage is governed by culture, religion, and custom and usage. And he goes on to say that the institution of marriage is, quote unquote, mystic, M-Y-S-T-I-C, mystic, and therefore not capable of judicial investigation. The purpose of marriage is not subject to judicial investigation. Now, I think this is not only an unconstitutional view, it is also, it denies equality to everybody. It's not, this is the view of marriage, not just for same-sex marriage, but also heterosexual marriages. They're divinely sanctioned. They are mystic. I don't understand what is mystical about a marriage. Certainly my marriage with my partner is not a mystery to me, nor is it mystic. It is really based on mutual respect and friendship and love and affection, all of which are very real to me. And apart from that, there is nothing more secular than the institution of inheritance of property. Inheritance linked to marriage in every community, in every religion, and yet we call these laws personal laws linked to religion. Something as material as who will inherit my jaidat, who will inherit my chair, my furniture, my land, my bank account. It's real, it's material property. There's nothing divine about these goods. And yet, we are told that no, all this is a mystic experience. So we need to really subject our judges and their judgments to a critical constitutional review. I feel particularly strong about this issue of marriage. I must tell you this. I once handled a case of a lady which arose from Karnataka. She was married off against her consent. But this woman was very smart, and while the Saat Feras were taking place, she was sending SMSs and messages to the Commissioner of Police. And she said in those messages, I don't accept this marriage. I don't want to get married. This marriage is without my consent. So while she was doing the Saat Feras, she was sending these messages to the police and come and help me, come here, come and get me out of here. Well, the marriage took place. The Commissioner of Police was hand in glove with the two families concerned. This lady then managed to escape and come to Delhi, and she approached the Delhi Commission for Women, who in turn came to me. So I said, how is this possible? This is not a marriage. How can you call this a marriage? Then I quickly took out the Hindu Marriage Act, and to my horror and surprise, I found that the Hindu Marriage Act nowhere says that the consent of the parties getting married is required to the marriage. There was an indirect reference to it when it came to dissolution of marriage, but no definite statement that the two parties who are getting married must consent to getting married. This is Hindu law. You can read it up. And I then filed a petition in the Supreme Court, Article 32 petition for her, and it came before a bench presided over by Justice Deepak Mishra. And I must tell you, the most brilliant arguments in the world are the simplest. And I just stood there and I said, sir, this marriage has no consent. Will you call it a valid marriage? That's all. 2 sentences. I was just telling these students, they said, ma'am, you're going to speak for 2 hours. I said, no, the best speeches are the briefest. And when you go to court, you must remember that you will be told that if you can't win over a judge in the first 5 minutes, you will not win him over or her over after arguing for 24 hours. You can do what you want, but your argument is here in your head. And so I told the judge, I said, sir, is this a valid merit? Here are the SMSs sent to the Commissioner of Police, and Justice Deepak Mishra looked at his colleague, and his colleague looked at him. They didn't know how to handle this Ms. Jaising, who comes up with the most weird arguments. And he realized that there was something of a revolution taking place inside the courtroom in the argument itself. And then he quickly, that was Justice Deepak Mishra's master talent. He knew how to bring about settlements and compromises. And he did exactly that. He issued notice to her. No, Ms. Jaising, we will issue notice to her parents. Let us see what they have to say about this. So he issued notice to the parents, and he got the parents to admit in court that they will not object to her filing a petition for divorce on the ground that she didn't consent. And then he didn't want the Supreme Court to decide that the Hindu Marriage Act was an act which didn't require consent of the parties to the marriage. So this girl then went to Karnataka, she filed a petition for divorce, and she got a divorce decree. So the reason, what I felt when I read this judgment, that not only was it unconstitutional, but it was also ahistorical. And I've recently been reading a book of a biography of Rukmabai, who more than a century ago, how old did you say is your college? 150 years. So 100 years ago, Rukmabai was faced with a petition in the Supreme Court, in the High Court of Bombay, for restitution of conjugal rights. And she argued that I never gave my consent to this marriage. I was a child. And so you cannot pass a decree for restitution of conjugal rights. This is the history of the women of India. This is their history. This is their struggle. And a judge, when he says that the institution of marriage is mystic, doesn't know his history. And is required to then go back to history and read the Constitution and come back to fundamentals. Now, this is, as far as I can see, for me, the issue of independence of the judiciary. About the collegium, you all know, but I also feel that the collegium is not being implemented in letter and spirit. And there have been calls for changing the collegium system itself. For me, the most outstanding example of failure of the collegium system, you can call it that, and lack of transparency, was the appointment of a judge to the High Court of Madras, Chennai, Victoria Gowri. And the videos that emerged about her utterances before she became a judge or was administered the oath of office, she said, Islam is green terror and Christianity is white terror. Now this is to be characterized as hate speech. And as the case was being argued in the Supreme Court of India, the oath of office was being administered to her. Ask yourself the question, is this independence of the judiciary? Is this the way the collegium system is meant to function? Was there a protest by the collegium that don't appoint somebody like this? We will never know, because none of those proceedings were ever made public. All we were told is, sorry, there is no judicial review of appointments to the High Court or the Supreme Court of India. I think it is an anti-constitutional proposition which requires serious change. I'm going to conclude by talking to you about what I consider to be the issues of the future decades, which you will be called upon to appear in court and argue. And those are the issues of life and liberty. Life and liberty. Today, we are surrounded by 3 or 4 laws which, it's like if you're wearing a sari, you're wearing a sari of these three laws or whatever. One is the NDPS Act, the other is the UAPA Act, the third is the PMLA Act, and the fourth is the Foreign Funds Act. Now, the first three do away with the non-negotiable constitutional provision that is, we are innocent until proved guilty. They tie the hands of the judge to grant bail to anybody by saying, you must be convinced that they are prima facie not guilty before you grant them bail. An unheard of proposition. Section 50 of the PMLA enables an enforcement directorate officer to come to you and take your statement and make it admissible, notwithstanding the fact that no statement made to a police officer is admissible in a court of law if you're an accused. And this is done only in the name that an ED officer is not a police officer. So his statement can be admissible, but you will not get bail. And it's the same with NDPS. Now, NDPS fails to distinguish between traffickers and consumers. And you go to any state in the country, go to Punjab, you will see young people in jail for consumption of small amounts of a narcotic substance. Now, Madam was talking about delays. How can you not have delays if your jails are full of people who have committed the most petty of crimes and they are told that you will not get bail? Of course, your jails will be full. It's not a question of just increasing the number of judges. It's a question of abiding by your constitutional principles, innocent until proven guilty. So these are the challenges of the future that you will have to address. Tell me, if I was not a free person, would I be here, able to come here, stand before you and address you? No. Freedom is the most precious thing in the world. Your voice is the most precious thing in the world. And this is why it is your duty to safeguard this freedom. Now, what happens when you go to court? You see in front of you. What do you see in front of you? You see in front of you that the people that government wishes to prosecute will find themselves with an FIR. And those that they do not want to prosecute will find amnesty. It's simple. All you have to do is not register an FIR. And if I don't want to prosecute you, that's all I need to do. So this is the rule of criminal law today. It is an FIR for your opponents, an amnesty for your friends. It is not prosecution that you see in this country. You see persecution. And it is here that you would expect the Supreme Court to rise to the occasion in the role of independent arbiters between the citizen and the state and to declare these laws unconstitutional. Instead, what do we see? We see instead that those of us who take cases to court, we are told that you are the criminal. It happened to Madam Tista Settlebar. All she did was go to court and challenge a certain pogrom which took place in 2002 in Gujarat on behalf of Zakia Jafri. And she ended up, after a 10-year litigation, being called a criminal and being arrested. She's lucky, of course, that she's on bail, but she's on bail. She's not free of the taint of being called a criminal. So there is an abuse of the criminal justice process. Now, what happens when you say that the law is being abused? What happens is the judge will tell you, of course, Ms. Jaising, this law, in your case, there has been an abuse, and we will give you bail because the law has been abused. But when abuse becomes policy, it's time for the courts to deny the power of arrest to these institutions. And it happened to the founder of NewsClick, Prabir Purskaya, who 200 journalists had their devices confiscated. It is a stroke of luck that he finds himself a free man today, because the grounds of arrest were not supplied to him before the remand was made. Then we all know of the Bhima Koregaon case. We've seen Stan Swamy die in prison of ill health, of denial of the right to health, and the only person who really managed to escape death was Varavara Rao, as you know, a famous poet from Andhra Pradesh, on the ground that the state was not able to protect his right to health, which is part of the right to life and liberty. I am going to stop over here. I've said enough. I've said a lot of what I wanted to say, and I look forward to your responses and your views. It's time for me to listen to you. Thank you very much.
Thank you, ma'am. Words of wisdom from one of the founding daughters of Constitution would make an exquisite caption for this session, I think. So I would like to assure you that we, the Government Law College Ernakulam, has never hesitated to exercise our right to freedom and expression, freedom to speech and expression. And also, the word Azadi has always reverberated in every nook and corner of our college from times unknown, I must say. And also, thank you for giving us a new goal in life as lawyers to dismantle the social hierarchy. We shall take it to heart. And now, we shall extend our gratitude with a memento of appreciation, and I would like to welcome our principal, Dr. Bindu Namyar, to do the honors. Thank you, ma'am. Thank you so much for those beautiful words. That is a small token of appreciation from one of our students. It's a cactus plant. She's an entrepreneur herself, Shreya. It's a token from her. Thank you, ma'am. Now, we are giving the audience a chance to ask any questions that you have in mind so that we can enlighten ourselves. You can raise your hand if, yes.
Hello.
Please introduce yourself and you can ask.
Hi, ma'am. Myself, Anak, a doctoral scholar in political science under Mahatma Gandhi University. So my question is, the amount of hate speeches against several minority communities, including Muslims or queer or anybody, is increasing day by day in this contemporary era of extension of right wing to all loops and corners of the society. But at the same time, we can't see any action that is being taken against from the head of the state towards any human being who is taking any sort of action through social media or in public spheres that is extending the attacks towards the most marginalized in the society. So that has been increasing recently that we can see. And there is no action being taken against anybody who will be more powerful or less powerful it is. So how can we say that there is freedom for the minority? The freedom itself is becoming more intersectional these days. Freedom is there with the hands who are more powerful, but the freedom of being themselves is not there for them who are less powerful in this society. Of course, issues demanded. So what's your say on that, ma'am?
I can only agree with you on your analysis, and you are a political scientist, so I feel you're better equipped. Can you hear me? No? Yes, okay. So as a political scientist, I feel that you're better equipped to answer this question than I am. The law in this country on hate speech is certainly underdeveloped. At the moment, all we have is Section 153A and 295A, which, as you know, were introduced by way of amendments to the Indian Penal Code. But I would say it's an issue that is a worldwide issue. The world over, there is a division of opinion on this question of hate speech. But I feel that in India, what you say is particularly true. And what is heartbreaking is that we have seen it happen during an election season. And we have seen the failure of institutions, because the first level autonomous institution that should have dealt with this kind of hate speech during an election period was the Election Commission of India, which they failed to do. So my only answer to you is that every single act of hate speech needs to be challenged. Yes, I do have this grievance that we have also failed to challenge every single act of hate speech in a court of law. Now, it's very exhausting, to go to court and challenge anything. But the law can only develop if we challenge. Also the question of abuse that I brought up, because judges will tell you, yes, 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 this is wrong and that is wrong, but it doesn't stop the problem. There have been cases which have been taken to court where people have been hauled up for hate speech, not that they haven't been. I am currently handling a case from Tamil Nadu, where the leader of the BJP, Annamalai, was taken to court for a certain statement he made, which was completely against the minorities. And the High Court, he went to court for quashing the FIR. The High Court said no, the trial must continue. He came to the Supreme Court and he got a stay of the proceedings. So one of the problems is that the law has linked the question of hate speech with the potential to cause violence. But it's time for the law to recognize that hate speech in and of itself is something that needs to be stopped in a country which is so polarized as the country that we live in today, without necessarily linking it to violence, because in my opinion, hate speech is hate speech. Whether there's a potential of violence or that's not a relevant issue, so that needs to be addressed.
Do I have the privilege of asking one more question?
You have to ask the organizers, not me. They will decide.
Yeah, so
Whoever's chairing this meeting will decide.
yeah, so my question is again regarding, not related to this, but for me as a young scholar, I have been hearing the name Indira Jaising when I was studying about gender-based legal fights, and of course Mary Roy case. Can you please share your experience of having the fight for the Christian hereditary law and its amendment, etc. And you were supporting Mary Roy for her legal fight.
Yeah, I'll be delighted to do that. I have my colleague Lekha sitting here, but I have my own take on it. She may have her own take on it. As far as I'm concerned, the judges of the Supreme Court dodged the issue. Again, there could be no clearer case of discrimination than there was in the Mary Roy case, because there was a statute, the Travancore Christian Succession Act, which actually said that the maximum that a daughter can get is 5,000 rupees, and the rest of the estate would go to the sons. Now, I would say till today, I have not seen another statute which is as blatantly facially discriminatory as that one. Most statutes do not give you discrimination in black and white. Most statutes result in indirect discrimination, but this statute was directly discriminatory. So it was a brilliant opportunity for the Supreme Court, the bench headed by Justice Bhagath and Justice Pathak, if I'm not mistaken. They could have delivered a judgment which would have changed the face of this country for women. And they could have said, this is a blatantly discriminatory law, and struck it down under Article 15. They did not do that. What did they do instead? Instead, they said that all laws in the Part C state stand repealed. And therefore, the Travancore Christian Act stands repealed. Now, sorry, the end result was that women did get equal inheritance rights in the state of Kerala, but without a norm-setting judgment which said that this was discriminatory. So that is one observation that I have. Now, the consequence of that, because I kept in touch with Mary Roy throughout her life till the time she died, the consequence of that was that there were movements in Kerala to reverse the judgment. And she told me that priests were saying from pulpits in churches, advising men, make your will so that your property doesn't go to your daughters. So the only observation I can make is that social change and legal change needs to go hand in hand. Movements of women, not only women, but all of us together. Public opinion, earlier I used to think, oh, well, public opinion is such a vague concept, but it is not really a vague concept. It matters. And we saw the impact that public opinion made or could make when the Shaheen Bagh protests started against the CAA, that is the Citizenship Amendment Act. And you also saw how the 3 farm laws were withdrawn after the farmers' movement. So I'm not a political scientist, you are, but the only conclusion that you can reach is you need a combination of legal and social intervention strategies for anything to succeed. That's why I said when I spoke, freedom is not a gift that you have inherited. It is something that you fight for on a daily basis.
Good morning, ma'am. It's a matter of privilege for me to be attending this event. Myself, my name is Babu Bitolman. I'm a research scholar at National University of Advanced Legal Studies, Cochin. And first of all, thank you, ma'am, for giving us this wonderful thought that actually rekindled our conscience regarding our commitment to the Constitution. Ma'am, my query is concerning whether there is something called as too much independence of judiciary. For instance, you refer to the Indian Young Lawyers Association. You have been part of the litigation yourself. Because if you look at the judgment, we can see that contradicting opinions on constitutional morality that's been put forward by 2 Supreme Court judges. Does it actually create, because that actually creates an area of conflict or a thought of conflict regarding constitutional morality, because it's still being deliberated over judgments by the Supreme Court. So is there something called as too much of independence of judiciary in that context?
Okay. So I think the only answer I can give you is constitutional morality is nothing more, nothing less than what is contained in the preamble to the Constitution of India. That's it. Liberty, equality, fraternity, dignity. That's constitutional morality. And you can say we call it constitutional morality because there are no specific articles. Yes, liberty, 21 is there, the life and liberty is guaranteed, etc. But you take, for example, dignity. There is no provision in the Constitution which says there shall be dignity for every living human being. And by the way, now even animals are considered endowed with dignity. So what is constitutional morality? You need to first answer that question before you raise the question, is there too much of it? Constitutional morality is nothing beyond what you see in the preamble. So I would say no, there is nothing known as too much independence, but there are things known as wrong and incorrect and unconstitutional judgments of the court. But you know the famous expression, the Supreme Court is final but not infallible. And that is why you have institutions like this college, where you can freely criticize judgments of the Supreme Court. And the Supreme Court itself has said that we welcome criticisms of our judgments. And hopefully, I will not be hauled up for contempt of court for some of the things I said today about certain judgments of the court.
Good afternoon, ma'am. Myself, Aishwarya Babu. I'm from MJ University. I'm studying in School of Indian Legal Thought. So my question is based on the collegium system. You stated that the non-transparency of collegium system. And doesn't the selection process that is happening now indicate the presence of hierarchy in the collegiate system? And before you have stated that the articles 15, 16, and 17 were made for dismantling the same, the hierarchy system. Why is it not present and not used in the ways of selecting the judges in the collegiate system? Thank you.
I am not very familiar with the facts of the case that you're talking about, but I get a sense that your question is concerning the representation of diverse communities on the benches of our courts. So yes, it is a fact. I think our present Chief Justice, I don't think, if I'm not mistaken, has appointed a single woman during his tenure to the court. The last women that were appointed, I think, were appointed by Justice Ramana. I'm not exactly clear on that, but I know that there have been. Also, the dominant caste of the judges of the Supreme Court is Brahmin. So there is absolutely no doubt about the fact that the Supreme Court and our high courts as institutions are not representative at all of the diversity of this country, of the spirit of the Constitution, of constitutional morality, of Article 15, 16, and 17 for that matter. It's a big problem. Some years ago, not recently, I would say this was at least 10 to 15 years ago, I had read a report about a judge, and mind you, this was a judge of the High Court, who on taking office had purified the office he entered because the judge who was there before him was a scheduled caste person, conducted some sort of a ceremony or whatever. And it was, I think, Justice Joseph, if I'm not mistaken, from Kerala, who said that even the slogan that you see in the Supreme Court, Yatho Dharme Tatho Vijaye, has to change, he said. And, I was so pleasantly surprised when I heard a former judge of the Supreme Court say something like that, because he said this is linked to religion. And what are we talking about? Yatho dharme tatho vijaye, because dharma and the Constitution may be two different things. That was the swan song of the lecture that I gave, that, the norms are constitutional norms. And so, it is a fact, madam, that if we look into our own lives, we might find so many conscious and unconscious biases that many of us suffer from. And that is the reason why representation of affected communities is so important in institutions like the courts. Personal is that better now? Yeah. As a personal anecdote, and somebody mentioned in the introduction that I've done a lot of work on sexual harassment at the workplace. So Rupan Dev Bajaj's case I was arguing, which was really the first sexual harassment case to reach the Supreme Court. And the case got listed before a bench of 2 male judges. And she looked at me and she said, "Madam, the Supreme Court has given a judgment which says that a woman should be the chairperson of every sexual harassment committee. How come that in the case of the Supreme Court itself, there is no woman judge sitting on the bench?" To which my case is assigned. And I had to tell her, "Madam, the answer to your question is, at this point of time, there is no woman judge in the Supreme Court of India. There was none. It was an all-male court when her case was heard. And that's why it got listed before 2 judges. So this is just to tell you how litigants identify with judges depending on their own life's experiences.
Good afternoon, ma'am. My name is Sariga Ramachandran. I'm a final year LLB student in this institution. My question is regarding, as you told earlier, custom and culture as a source of law. In this diverse country like ours, is having a lot of personal laws, and still personal laws are guiding through the culture and different religions. I just want to know your take and your opinion regarding the Uniform Civil Code. Do you really think this Uniform Civil Code, if it comes, or our legislative, if it implements, this inequality will be equalized? Thank you, ma'am.
Okay, so I would prefer to answer this question a little differently in the way in which I wrote about it in relation to this marriage equality case. Now, you have to distinguish between substantive law and when it comes to marriage, you have to distinguish between what is the substance of marriage and what is the form in which a marriage is solemnized, okay? Now, when it comes to the substance of the marriage, it is consent, okay? So, there are personal laws in this country which say a marriage cannot happen until the woman says, Kabul, Kabul, Kabul. What is that? Consent, correct? And it doesn't exist in Hindu law. As I just told you, go read the Hindu Marriage Act, you'll find it's not there. So when it comes to the substance of a marriage, I believe that there has to be this equality, non-discrimination based on sex. However, when it comes to the formality, the manner in which a marriage is solemnized or it's registered, there can be a variety of forms in which it is solemnized, okay? Some may prefer to solemnize it as a nikah, some may prefer to solemnize it according to certain Vedic ceremonies, some may prefer to solemnize it by an exchange of garlands. There is something known as self-respect marriages. These are all forms in which marriages are solemnized. So this distinction has to be made when one is talking about Uniform Civil Code. Otherwise, it's a red herring. You know, I don't like getting into the debate on Uniform Civil Code because then the answers become political. Then the answers becomes, well, minority communities are beleaguered, so we don't want personal laws. Yes, that may be true. But even legally, there has to be equality. That is why I said that judgment of the Supreme Court under same-sex marriage, how can you call marriage a mystic institution? Please tell me whether you have a Uniform Civil Code or don't have a Uniform Civil Code. How can you call it a mystic institution? It is an institution which has real flesh and blood in it. It has sexuality in it. It has sexual desire in it. It has a monetary component. It has children. It has inheritance. These are all things which are very, very secular and which are very substantive. So these are the issues to be addressed. And ma'am, just one more thing I would like to put on the record, and that is that look at your criminal laws. People say that exception 2 to section 375 says that marital rape is not an offense. Now, I have disputed this proposition and the matter is pending in the Supreme Court. But how come there is uniformity on this question which concerns women so intimately? It doesn't matter whether you're a Christian or a Hindu or a Muslim woman. People say that rape by a husband of his wife is not an offense. Just look at the absurdity of the Uniform Civil Code argument.
Hello, ma'am. I'm Alina Susan Shibu from CSI College for Legal Studies, Kottayam. My query is regarding the inauguration of the latest Parliament building. So we knew how the inauguration was. The first Constituent Assembly was inaugurated in a constitutional manner, but the inauguration of the new building was completely like a religious rite. There was a historic entry with the Singol and all. So, and also in the next parliamentary session, there was a debate conducted on how there was a distribution of new constitution to every members of the parliament, and the word secularism disappeared from the preamble of the new copy. So, how do you, what is your say on the appearance of secularism in our country in the future?
In the future. Okay, that's why I said I wish you had invited me after 4th of June, but you haven't. So I think the future will depend on the outcome of the elections. And it's also connected to the first question that was asked, because I mean, if you look at world history, you know, dictators and autocrats are only prosecuted after they go out of power. What can you say if the instruments with which you prosecute belong to the person who you want to prosecute? Tell me. How can you do it? I was asked a question, why is hate speech not being prosecuted? Now you tell me. You've had these people like Anurag Thakur who said, Maro, Goli Maro, and no FIR filed against him. The judge gets transferred, okay? Why? Because those who we seek to hold accountable are the holders of the power to prosecute. So that is why history tells you that all these crimes against humanity get prosecuted when dictators go out of power. But the good news, of course, now is that South Africa has taken Israel to court in the International Court of Justice. And I'm proud to say one of the main not prosecutors, it's the counsel, Adila Hassan. She's a woman of Indian origin, and she has worked with me and my partner, Mr. Grover, as a junior. So we are very closely related to her, but credit goes to countries like South Africa, which have taken this issue of taking on a country like Israel, which appears to have universal support, including support from India, not to say the least, which is actually supplying arms, to the International Court of Justice. And the good news is that the International Court of Justice first said that this is bordering on genocide, and then they went on to say, stop all hostilities. Now, whether they stop or don't stop, international law will be made or broken on the issue of Israel. And now the International Court of Justice has issued a warrant of arrest for Netanyahu. So if he travels out of Israel, he's liable to get arrested. So it's again, madam, a continuing I'm tempted to say there's no future, there's only today. And today the only thing you can do is fight, struggle.
Hello, ma'am. Good morning. My name is Varsha Singh, and I'm a first-year BA History student from Sacred Heart College, Chalakudi. So, ma'am, my question is about the judicial review system of the Indian judiciary. Don't you think the repeated intervention of courts can diminish the faith of people in the integrity, quality, and efficiency of our judiciary?
I'm sorry, can you just repeat, what will reduce the integrity of the judiciary?
The repeated intervention of the courts in cases.
Repeated intervention of the courts in cases will reduce what?
The integrity, quality, and efficiency of our courts.
Now listen, I'm not sure I've understood your question, but you are questioning the basis of judicial intervention and saying that that kind of intervention can reduce are you trying to say credibility of the judiciary, that the credibility of the judiciary will be reduced?
I'm asking about the judicial review system. The reviewing of a case again and again after, even when a verdict is already given by the Supreme Court.
You mean review?
Yes, review.
The review jurisdiction of the court?
Yes, ma'am.
Okay. Now, you know that no system of justice should exist without a system of review, because as I said, the Supreme Court may be final but not infallible. So the system of review is a very important safeguard to for the judicial system to function at all. Now, on top of the review, the court also introduced the curative petition, as you all know. This is something you learn in law school, the Ashok Hura judgment. So this again was introduced to prevent a failure of justice or a miscarriage of justice. And the grounds are very limited. Either natural justice has not been complied with or completely some statute has been ignored. So in principle, I do not agree with you that a review system is going to weaken the judiciary or reduce its credibility. However, the entire institution, the problem really is that the judicial system is judge-driven. It really is. And the amount of discretion that judges have, they have unguided, unlimited discretion. And, well, they can admit review petitions if they want to, they can dismiss them. They can admit curatives if they want to, they can dismiss them. They can appoint anyone they want to appoint as amicus. We don't know why, we don't know how, we don't know when. And they can basically drive the courts in a particular direction. So the problem really lies there. It lies with unguided judicial discretion. And you all know the current controversy that's going on in the Supreme Court about the master of the roster and how cases also get assigned in a mysterious, that the mysticism comes in over there, by the way, in the manner in which cases are assigned to different judges. So we are living under a judge-driven system, and that is something that we should be looking at. That can affect the credibility of the court.
Good afternoon, ma'am. I am Keshav, a second-year UG scholar in law, studying in the Tamil Nadu National Law University. So my question is, since the first question came up around the hate speeches, there have been a hell lot of hate and controversial speeches being delivered across this election season, ma'am. But the ECI has been so far not so efficient in curbing those speeches, irrespective of the parties as such. And we have this moral code of conduct in effect that strictly prohibits such speeches. Now, is it fair to say that the Election Commission has become a partition body of the executive of the present day? Because I don't want to use the word ruling party, that's why I'm using the word executive of the day. And of course, we do have certain instances, but largely it hasn't favored, it has favored the ruling party as such. This is my question.
Yeah, I think you can raise this question tomorrow when you have Justice Joseph, because he's the person who was party to the judgment on the Election Commission and its role and the way they're appointed. Yeah, it does go back to the way they're appointed. It does go back to executive control. I also don't like to use expressions like ruling party, and I did try to avoid them. We are concerned with separation of powers between the executive, the judiciary, and the legislature. The three arms of state, and I would say the media, the fourth. And what about we the people? So we have a distinct political identity of our own. So obviously the question you're raising relates to what has happened to what are called fourth level institutions. Fourth is considered the media, and fifth is considered these autonomous. And your question cannot be confined to the Election Commission. What about universities? Why were the police allowed to enter JNU? Why? For what reason? Okay, does it not raise the question of autonomy of those institutions? Why are we focusing only on Election Commission? Who are the vice chancellors being appointed of universities? Why are students being picked up for protesting against Palestine? It's because institutions have lost their autonomy, or because we the people were not vigilant enough. Wherever we go, people ask us, do you think the elections will be manipulated? What answer can you give to that question? The only good news that I've been hearing across the country is it's not possible to manipulate the elections anymore because citizens have become vigilant. And there have been cases where citizens have protested, voters have protested, where attempts have been made to introduce new EVMs which did not exist. So we're, arguing in circles. We are back to the politics of majoritarianism and authoritarianism.
We will be taking 2 more questions.
Madam, we are very honored to hear your very, not only your learned and erudite presentations and comments, but very activist and passionate. I'm just a guy from the public, not from the part of the legal fraternity. So what I found very interesting is that to give an example, you have been more than once you stated that about the recent topical incidents, like say Supreme Court judge recently talking about in her judgment, the marriage as a mystique or a sacred thing like that. So, but as a out of not from the legal fraternity, if I look at it as a middle-aged person, I find that there is a what you call need for a a discernment or a type of grainy discourse, not black and white discourse like that. Because I studied in 80s and like that. So a lot of, in 90s I found in my own class, degree class, some divorce cases like that. So some of them, when I was in Bombay, when I came back to Kerala, I found that these cases, or 2 of the cases were Christian things. And they are, of course, well-off families or middle-class families. And these sacred things came there because even then the court granted divorce. According to the Christian thing, the marriage is a sacred thing, a sacrament. And after that, the 2 persons become one, and so many other things are there. Then biblical this thing also is there. So that was one thing that has been especially ingrained in Kerala, and the Miri Roy case, somebody else mentioned like that. So when you're making this presentation, is very, very powerful and passionate presentation, that thing also stands in the background. And that same thing appears when you're saying about that Supreme Court Chief Justice Deepak Misra also, how he said that was his genius or a thing of making compromises instead of taking on directly the bull by his, taking the bull by his horn directly.
Answer it. I have understood the question. May I just answer it, please?
Okay.
Yes.
So just the thing is that, one minute, madam. The professional actually, the advantage of professional is basically functionality. Only at higher level, academic, intellectual level.
I have completely understood your point of view. Please allow me to answer the question. Now, please separate the 2 issues. One is you talk about marriage. And sorry, not about marriage. You talk about divorce. You don't talk about marriage. Okay? Now, I think there is a certain background to this, and your perception of me is a person who represents women, and therefore I will always support a woman, right, wrong, or indifferent. Now, this may or may not be true, but let me take your question head on. Yes, I referred to Justice Deepak Misra as achieving a compromise. However, I did not refer to it in a pejorative manner. Remember that. I did not say he was wrong. He achieved the end goal. The end goal was this woman had to be liberated from the marriage, and he did it. So I was not critical of Justice Deepak Misra. I was giving you a fact that this is how it was done. Secondly, as far as the sacredness of marriage is concerned, I did answer the question raised by the lady who talked about Uniform Civil Code by saying, you may consider it sacred. I have no objection to that. It's your individual point of view that it's sacred. But when it comes to the substance of the marriage, there must be consent. And even in the sacred marriage, the woman is asked, do you take this man to be your husband? What is that? Is that not consent? And all that I was saying is that in Hindu law, this consent is missing. So I think there is a confusion over here. And the last thing that I want to say is, sir, whether you like it or not, for me, the Constitution of India is not negotiable. And it cannot be negotiable for any judge. We all have the right to religion, guaranteed under Article 25 and 26 of the Constitution of India. But we cannot allow that to spill over to our public lives. And marriage does have two elements to it. It has a private life and a public life. And that is why I said, I visit temples. I am a very religious-minded person, but it will never affect my understanding of the Constitution or the law.
Thank you, ma'am. Thank you for such an integral session. I myself, Siddharth, I am a student at Government Law College, Ernakulam. Ma'am, you told us about the current scenario of the independence of judiciary and judges of various high courts while saving the justice. As you stated, ma'am, judges are quoting Manusmriti and other thousands of year old scripts, religious scripts for while delivering the justice instead of quoting Constitution of India. Ma'am, recently in a farewell speech, Calcutta High Court Judge Chittaranjan Das revealed he is a member of RSS. He stated, quote unquote, "Today I must unfold my true self. I owe a lot to one organization. I must admit here that I was and I am a member of RSS." Ma'am, should a judge who serves justice to the people of India and who interprets the law of the land or himself to the ideology of constitution instead of the ideology of an organization?
Okay, just, there was one thing, and it concerns the question of the previous speaker as well, which I was planning to say when I delivered my speech, and I'll say it now. Thank you, sir, for the opportunity to say this. What I would like to tell you is that when we talk of independence of the judiciary, there's only one institution that can make sure that the judiciary is independent. That is the legal profession. Okay, you remember one thing, if the executive has to get to the judges, they have to go over the heads of the lawyers. They cannot do it without the legal profession becoming a collaborator with the interference, okay? And that is why when we talk about independence of the judiciary, we also have to talk about the role of the legal profession. The role of the legal profession also has to be independent. And that links, that I was intending to say this, and if you have noticed, some of you might have noticed the outcome of the result of the election of the SCBA in the Supreme Court of India. All of you may have noticed that the previous president of the SCBA would thank the Prime Minister of the country for everything that was going on anywhere. Now you noticed that Mr. Kapil Sibal got appointed as the president of the Supreme Court Bar Association, and he got appointed by a pumping majority. This means that Mr. Sibal has been able to bridge the polarization that existed at the bar and the polarization that you were talking about. I don't believe in polarization. Polarization has killed this country. So please don't walk away with the impression that Ms. Jaising has come here to polarize the people of this country. No, there is a great merit in being able to bridge the gap which we are seeing in this country between what are known as right-wingers and left-wingers, or liberals and Democrats on the one hand, and Hindutva forces on the other hand. That's not our job. Our job is not to deepen that divide. Our job is to unite people under one banner, and that is the Constitution of India. Therefore, it does require interpretation. The Constitution requires, therefore, the Constitution cannot be contaminated with religion. You're welcome, we are all welcome to have the right to religion. This was the argument in Sabrimala, which was expected, which was accepted. And it was, the Sabrimala judgment has gone for a review. It'll never, God knows when it'll be heard. It's gone to 9 judges now. One single woman climbs up the hill and goes to Sabrimala, and the world comes to an end. This is also the power of women. Take it from me. Okay? One single woman had the power to change a lot in this country. So it's a matter of great pride that today the Supreme Court has been able to elect a person who has been able to bridge this divide, who is not a polarizing figure, and we are looking forward to true, independence of the bar and independence of the judiciary. So about your question of the RSS, yes, this man certainly didn't declare when he was taking oath that he's a member of the RSS. And as far as I see, it is the oath of office which the judge takes which has been breached. Now, if you want to raise a legal question, I'm not sure that it can be taken to court once the person has retired. Okay, if you're a sitting judge, because I know when one of the judges from Calcutta was impeached, Justice Singh, the impeachment process went forward, but he resigned in between and it was not carried forward, okay? So, but if a sitting judge says that I am a member of the RSS, then I would take it that the ideology of the RSS is counter to the ideology of the oath of office that the judge has taken.
One final aspect, nothing related with constitutional thing. Because while we were speaking while we were there at the principal's office, I was mentioning about the way in which the law students have to shape their perceptions. So we, the legal fraternity assembled in this particular auditorium, is privileged and honored to have an iconic figure like you. And just to take a minute and tell the students as to how they have to travel beyond this syllabus and to reach out to the different stratas of the societies and take first-hand experience from them to shape up their conviction to become a person like you who can, or rather for other persons, who can lead fight on behalf of the society. Thank you. And that will be the last question also. Thank you.
That's so, yes, when we were sitting there, I think the question really was that two things I said. One is, an academic approach to a problem, and what's the word for it? A direct approach? Give it any name, it doesn't matter more. But the experience of life. The experience of life. Okay, so my approach to the law is not academic. My approach to the law comes from my experiences of life. And of course, a lot of my experiences of life have come from the people I've represented also. Mary Roy taught me things which I didn't know before. Rupandev Bajaj taught me things I didn't know before. People like Geeta Hariharan taught me things I didn't know before. Who was Geeta Hariharan? She was a woman who wanted to make an investment in the name of her son, and she was denied the right to make an investment because she was not the natural guardian of the child. So I guess what I was trying to say, it's exactly what Justice Chandrachud said in Indian Lawyers Association. We are dealing with two struggles, not one. We are not dealing just with an independence struggle. We are also dealing with the struggle for social reform. And that is the reason why I drew attention to Rukmabai. I was amazed. There's a new biography of hers. I'll share the name with you. Sharat Chandra has written it. You read it. It's a short little book. But it was a century ago where someone just said, I was a minor when I got married. And I refused to go and cohabit with this man because I didn't give my consent. And something as elementary as that is being disputed today. And today what do you have? You have anti-conversion laws, which say, come and prove to me that you really want to marry this person. Why? Why do I have to prove to anybody that I'm going to marry this, that I want to marry this person? It's my choice to marry a person of any faith. So things have changed, but you're right. There is someone I know who is today the Vice Chancellor of a university. I will not mention his name to you because this is not about names. And he said to me that his very first inspiration for getting into the deep into the legal profession was working with me, and seeing the way I was handling public interest litigation, which is what the Supreme Court said. Public interest litigation is about empirical data. It's about empirical data. Go there if you want to elevate the purpose of the status of living in a slum. Go to the slum, please. And what did I do when I was arguing the pavement dwellers case? I walked the streets of Bombay. I walked through the pavements where people were living. I saw women giving birth to children on the pavement. I saw women cooking their meals on the pavement, not because they wanted to. They didn't have a home to call their home. So these are the inspirations that we get in our life for doing the work that we do. So therefore, I have to thank you, Mr. Giri, for giving me this opportunity for saying these two things that ultimately, take it from me, it is only the legal profession which is going to protect the independence of the judiciary from the executive. They cannot reach the judges without going over our heads, and we will not allow them to go over our heads. Thank you.
Thank you so much, ma'am. So I would like to specially mention that Indira ma'am is also the co-founder along with Anand Grover of a website called The Leaflet. So you can all dive into that and know about her new ventures and everything that is related to law. And you can also write to her through that website. Thank you, ma'am.
Thank you for pointing that out. I will ask you to share the link with them. It's www.theleaflet.in. And we welcome articles by students. Mr. Giri, it's also part of the journey, because you have Sarabha sitting here. When we started the Lawyers Collective, we had a print edition called The Lawyers. And it's funny, but I meet people today who are designated seniors who tell, oh, Ms. Jaising, we were reading the magazine when we were students. I said, really? All right, now read the digital editions. So thank you, ma'am.
Okay, now we have a small ceremony to get done with. We have our overall champions here. Dr. Ambedkar Law University winners, the overall winners. Can you please come forward to the stage? And I would like to request Indira ma'am to present them with the award. Please give them a loud round of applause for their wonderful participation. For submitting the highest number of papers. Let us not stop with the applause. This will be a moment that will be remembered forever by Law College as well as Ambedkar University as well. Thank you, ma'am. Thank you so much. Now we are moving on to the final part of the session. I would like to welcome our Law Journal Club convener, Sangeet Krishna, to propose the vote of thanks.
Hello. The hard truth is that all animals are equal, but some animals are more equal than other animals. And the right place is here, and the right time is now. So, for a change, greetings, we the people of India. As we conclude the first session of our national conference on the Constitution in a Changing India, it is my honor to extend a vote of thanks on behalf of the Government Law College Ernakulam, College Union, Law Journal Club and Bhagath Singh Study Circle. The session has been an enlightening start to our 3-day conference, and we are grateful to everyone who contributed to the success of the event. And first and foremost, our deepest gratitude to God or science or both, which created and made our existence possible. Most importantly, next we would like to point out and quote, the God or the supreme authority which we have created. Yes, I said it right, the God or supreme authority which we have created, which has ensured our peaceful coexistence and provided us with a framework for justice and harmony. Many of you had guessed it right, it is the Constitution of India, the God which we had created, which ensured a peaceful coexistence in our society. The Constitution continues to guide us through the complexities of a changing nation, and it is the very reason we are gathered here, and it is this very same reason which lawfully gives us the opportunity to gather here. And further, it is the same reason which gives us the opportunity to speak freely, and it is also the very same reason which will allow us and grant us the opportunity to speak freely in the future, whatever happens on June 4. And special word of thanks goes to our esteemed speaker, Advocate Indira Jaising ma'am, for her insightful and thought-provoking session on the constitutional imperatives of an independent judiciary. Your expertise and dedication to the field have set a high standard for the discussions that will follow, and we are truly grateful for your presence and contribution, ma'am. So, as the proverb goes, well begun is half done, and your session has undoubtedly laid a strong foundation for a truly enriching conference, ma'am. Further, we wish to thank the Principal of Government Law College Ernakulam, Dr. Bindu M. Nambiar ma'am, and our beloved teachers, Dr. Premsi ma'am and Dr. Mini Paul ma'am, for their presence and continuing and unwavering support. Also, I would like to thank the chairperson Farhan and Sanjana, the vice chairperson, the captain of this ship. Next, I would like to thank the both ma'am who had come over here. Your presence greatly matters so much to us. Then the special mention to Girishankar sir, who have been unwavering pillar for this conference. As the saying goes, we can only paint when there is a wall. And if there is a wall, the one single answer for that is Girishankar sir. Also, a special acknowledgement goes to the organizing committee and the volunteers from the Government Law College Ernakulam. There is a saying that sometimes truth is stranger than fiction. Many of you have witnessed waterlogged areas which you have seen inside the college. They are not just rainwater. They are also represent the sweat and tireless efforts of our dedicated volunteers. Well, that was my prepared speech, but man proposes, nature disposes. Many of those waters have evaporated. So, even though the water has evaporated, the efforts of the volunteers are an undisputable fact. And thank you all the volunteers for your extraordinary dedication. Then our sponsors and partners, thank you for your generous support. Your contributions are invaluable in making this conference possible and promoting critical disclosure on our evolving constitution. A special thanks to the LiveLaw team, our media partner, for helping us reach a wider audience and ensuring the discussions here resonate beyond these walls. Finally, thank you to each attendee, whether in person or virtually, for your participation. Your involvement is crucial to the success of this conference, and we look forward to your continued engagement in the upcoming sessions. As we carry forward the learnings from this conference, let us remember the enduring importance of the Constitution in navigating the complexities of a changing India. May we strive to uphold this principle and ensure that it continues to be a beacon of justice and equality for all. So, let me end by saying that all animals are due equal. Let's all walk the talk. Thank you once again, and see you at the next session by Nagaraj Narayan sir. Thank you.
Thank you everyone. Thank you ma'am for being here. So we'll move ahead to the next session after the break.